Yesterday, Amy said that her panel was the best. I'm going to argue that this is the greatest because I have, thankfully, and for all of us here this morning, I have a panel of the great advocates and trial lawyers in the room. I think you'll know that several of the names will be familiar to you. We have some of the best advocates from both the US, Canada, and the UK here today to discuss enforcement and prosecution matters. We'll be working on the hypo that we've all discussed previously, but before doing so, I just want to go into why enforcement is such a topical issue, and you needn't really go further than the morning's FT headlines to understand the implications of what we're about to discuss today. There was regulation of cryptocurrencies in there. There was a sentencing of the ex-trader, Matthew Connolly, in LIBOR in the, I think, Southern District. The New York Times yesterday led with the Deutsche Bank campaign in China, whereby there were crystal tigers and $4,000 bottles of wine at issue, whereby the political elite were being wooed by the Deutsche Bank execs on that front. So with that, I want to turn to my esteemed panelists, starting with Stephanie, who is next to me here. Stephanie is a partner in Hoban Lovell's office in Los Angeles. She worked as a prosecutor in LA for more than 14 years. She oversaw the investigation of the hacking of one of the world's largest entertainment companies on behalf of an alleged foreign government. And she maintains a keen interest in all things cyber, so cyber crime and cyber security related. Next to Stephanie, we have Mukul Chalwa QC. Mukul is one of the leading silks and one of the leading members of London's criminal bar and has been for over the past 35 years. He's was head of Foundry Chambers for several years before joining today's firm, BCLP, last summer as a partner in their white-collar practice. The Times, that's the English Times, called him one of the most successful criminal barristers in England. He has been instructed by the SFO on one of the largest multi-jurisdictional investigations, the Emanuel investigation, and he acted as for the defendant in the first ever contested prosecution for bribery. He led the SFO's team investigating LIBOR and several other matters. And then next to Mukul, we have Peter Mantas. Peter is the partner and co-leader of Fasken's White Collar Defence and Investigations Group in Ottawa and Toronto. He has acted in some of the most prominent cases in Canada and has appeared before the Canadian Supreme Court on several occasions. And then finally, we have Mr. Bill Burck, who is co-managing partner of Quinn Emanuel's DC office. At this point, I will say I'm a former Quinn Emanuel associate here in London, so thank you, Bill, for joining us. He's co-chair of the firm's investigations practice. The New York Times called him one of the country's top lawyers, and he was named DC's White-Collar Crime and Government Investigations Lawyer of the Year this year by Chambers. He's a former special counsel to President George W. Bush and was an AUSA in the Southern District and a senior official in the criminal division of the DOJ. And so with that, I'd like to kick on where we last left off with our hypo. We covered in particular some of the jurisdictional issues, and I want to just go over those again. We won't be looking at the World Bank this time. We'll be looking at the UK and the US and how in the event of joint jurisdiction, how that actually plays out. So Stephanie, are you in a position to tell us a little more about what can happen when the DOJ gets involved in enforcement matters, but there may be other issues at play?
Yeah, let's hope so. So with respect to the multi-jurisdictional aspect of any of these international investigations, it's interesting because it has evolved in a way over time. It used to be that the DOJ just came in and stomped about and took everything, and there wasn't a lot of coordination probably about 10 years back. And as you heard yesterday and today, there is increased cooperation. And I think what that means is that you have to take into account not just the SFO and the US, but every government entity that your operations are going to touch that you might have risk at with respect to assessing self-disclosure and jurisdictional issues along the way. It used to be, and Bill can talk about this too, that the U.S. attorney's offices themselves, there are 94, used to fight. It was the first to the door. So, and they still might fight a little bit with respect to who gets to bring a case. But more and more, especially with Lisa Osofsky at SFO, I do think the cooperation's increasing.
I fully agree with that. I'll just speak. So I think that's exactly right. I think Lisa Osofsky is a very important point as well, because I think that her leading the SFO has changed, I think, the way that a lot of DOJ prosecutors think about the SFO. I think for a long time they sort of saw it as either a very junior partner 10 years ago. I think that it evolved into an important partner, but kind of a competitor. And now it's much more, I think there's a sense that there's more of a cooperative relationship. So I think that it's a lot about people. And I think that you look at some of the people who were running the significant white collar parts of DOJ, the fraud section or the Southern District or the LA U.S. Attorney's Office. And they have particular contacts and friendships and colleague relationships with people over in the SFO, including with Lisa. And I think that's really driven a lot of the cooperation.
I mean, I worked on the first DPA here, and the SFO was given jurisdiction simply because we needed in the UK the first instance of a DPA, and so I think the DOJ was happy to allow the SFO take the lead in that instance. But what, for example, happens when you have equal jurisdiction and both entities, both on the side of the Atlantic, are keen to take charge of that? Muireann, in your experience, have you seen anything that when there's a real issue at hand and there's a bit of a fight going on, what happens?
Well, historically there have been issues. Some have been reported in the press. For example, and I'm not reporting things out of school here,
Of course.
when LIBOR first started, it was widely reported in the press that there was a turf war between the SFO and the DOJ about who was going to take primacy over that, whatever the rights and wrongs of that. By about 2013, whatever the relationship had been before, by about 2013, the relationship improved enormously. And there may have been some bumps along the road, inevitably, when you've got agencies who are keen to make their mark, as both the DOJ continue to be and the SFO rightly continue to be. You're going to have discussions, and some of them are going to be vigorous discussions about who might take charge. My expectation now, speaking now as a complete outsider, is that the appointment of Lisa Osofsky has been an inspirational one by the SFO, because it's brought into focus the very international character of the nature of the investigations that the SFO, in conjunction with other organizations, and not just the DOJ, as you say, but generally now conduct. So the whole issue, I expect, and this is me speaking very much as an outsider, is a much more collaborative one now than it was in previous years. Peter would be the one to know, but he would be the wrong person, I think, to ask.
Don't worry, we won't be asking.
Yeah. But that's certainly my expectation. And that means, in terms of law enforcement, that's only a good thing for law enforcement. And for companies and corporations and individuals who are going to be caught up in this process, they need to understand that. They need to understand that the chances are high that whereas in the past, if you just went to the SFO, you are unlikely to go further, that is no longer the position. This is now a global enforcement program which will be enforced globally, and that is very much my expectation.
And what then happens when you have multi-track parallel proceedings? We've heard of the Allen case earlier, where you have evidence used in foreign proceedings against particular witnesses. I mean, how are we going to deal with that going forward from a client point of view?
I think we learn by experience. Allen was a very unusual case, because in Allen, it wasn't the SFO who had the compelled interviews. It was, in fact, the financial regulator in London, the FCA, who'd had compelled interviews, which they were required to hand over and did hand over. And in fact, another witness, as I understand it, had sight of those interviews before giving evidence, which theoretically at least could have tainted that other witness's testimony. So it's an unusual situation, and we just need to be alive to the fact that there are, as Peter was saying earlier, tensions between different jurisdictions, not just in relation to what laws apply, but what rules apply to each of our jurisdictions. And we need to be cognizant of real joined-up thinking here.
Well, that brings us then on to collecting evidence and the collection of evidence internationally. And we have the Cloud Act, in the US, and here we have new overseas production orders that have just recently come into force, and we'll be seeing a little more of those. Stephanie, from your point of view, what does that mean in terms of, can you give us an overview of what cloud means from the US perspective?
Well, from the U.S. perspective, now the U.S. can go gather information from the cloud from companies that have the ability to do so from the U.S. and having just entered into the agreement with the U.K., that's going to cover the U.K. too. But there's this big unknown, which I think one of the panels talked about earlier, is the rest of the EU, right? That agreement is not in place, and there is a pretty big disagreement as to how that should take effect as it relates to EU data, and that's ignoring the rest of the world. So the cloud was a step toward U.S. law enforcement trying to get more information and now coordinating that with the U.K., but then that leaves the rest of the world still in a little bit of a position of unknown.
And Bill, from your practice, are you seeing, joint agency initiatives to collect evidence in various jurisdictions on a parallel basis? Is this something you've come across in practice?
Yes, although I still think that the MLAT process kind of is still dominant in terms of actually sharing information between, real evidence, unless it's in a cooperation mode. And then, so in a cooperation mode, I think some of the big issues that we deal with are the European data privacy rules, and dealing with DOJ or SEC or the CFTC or one of these other agencies. When you're in a cooperation mode, you will often be told by the prosecutors or the trial attorneys that, in order to really cooperate, you're going to have to give us access to personal identifying information of the people that you are investigating, the employees or the people that you are interviewing or getting emails from. And the problem with that is that does theoretically or maybe really violate potentially the data privacy rules over here. But the U.S.'s position or the DOJ's position has largely been, that's kind of your problem, and you need to figure out a way to give us this information, or we may not deem you to be fully, cooperating. And so I think that we've been working a lot with lawyers in the UK and in Europe on ways to try to get a little further with being able to provide information without violating the law over here. And of course, the law is developing here, but there's been a number of fines and penalties also already placed on companies for violating those rules. So there's a real tension there, and I don't think that anyone's really quite figured it out yet, from what I can see. And still, the safest course is the MLAT process. That's the one I think they still rely on when you're not in a cooperation mode.
And Peter, in Canada, what does that look like? Is there, the same concepts? Are you facing the same issues?
Well, I think so. Speaking for the rest of the world, we don't have a reciprocal treaty or anything like that on cloud with the United States. One will probably come in at some point, but the concern is that so much data is stored with an American corporation, perhaps not even a server located in the United States, but maybe so given our proximity. And there's a concern that there'll be no control over it. I mean, there's just, what are we going to do? It really isn't hitting the radar screen very much because it's a pretty niche area. It crisscrosses between tech and law, but the tech people seem to have caught wind of it a little bit more. And, you'll see people who are raising some questions as to what does this mean. As for the lawyers, I just think probably some case will come along and then we'll try to figure it out at some point.
Mm-hmm. And in terms of the collaboration between Canadian authorities and elsewhere, is that something you've seen in practice? We discussed earlier the Huawei case and what's going on there. I mean, can you tell us a little bit about that?
Sure. Well, I mean, because of the proximity of the two countries, there's a lot of cooperation that goes on. Huawei's, I'm sure most people here are familiar with the case of Meng Wanzhou, who is Huawei CFO. She's wearing an ankle bracelet and living in a $15 million mansion in Vancouver, Canada, as she waits an extradition hearing to the United States for bank fraud, actually, I think, in her case, in relation to violation of U.S. sanctions against Iran. And for those who are not from Canada, I'll let you know that never have the relationships between Canada or the relationship between Canada and China been worse. I mean, it's just, it has really put a strain to the point that actually 2 Canadians have been, suspiciously detained and incarcerated, without any evident cause in China. But in terms of evidence sharing, one of the things that's just happening in real time right now, over the last few weeks, is an application that's been brought by the defense team for Meng, alleging that. So what happened was when she arrived at customs, her devices were taken and placed in a bag, like the FBI does this a lot. They put devices or arrange to have devices put in packages so they can't be remotely wiped. Canada Customs doesn't do that. If you ever come to Canada, you'll see a much more welcoming approach. And so that happened, and then they started Customs asked her questions about Iran. That's not likely going to happen to you either, unless you are Iranian. And then after a period of time of a lot of questioning, she was detained by the RCMP and read her rights. I mean, we have a Miranda right type situation in Canada as well. So that got the defense wondering, what's going on here. And then they got some documents, started seeing some evidence that perhaps the RCMP, our National Police Force, had shared evidence with the FBI that had been obtained during the earlier period. So now the defense has brought an application to try to get more evidence on that, and potentially that type of aggressive evidence gathering could see Meng go in this spectacular case. And it's a lesson, I think, for police, prosecuting authorities, and defense to keep an eye out for that type of very aggressive evidence gathering and sharing. Because if there has been that kind of evidence sharing with the FBI at this stage in an extradition hearing, that could be fatal. I mean, time will tell. That could be major. Just one more thing. It doesn't help that the President of the United States at one point also said that if China cuts a trade deal with the United States, they'll let go of the extradition. But that's another issue.
Okay, thank you for that. I mean, the reason this arose is we were looking at the Bitcoin example in our hypo and how the evidence was collected. I know, Zoe, you mentioned that you haven't really come across any Bitcoin or crypto evidence collecting so far, and neither has anyone on this panel. Is there anyone in the room who has seen this in practice as yet? Okay, I think it's safe to say.
Have seen Bitcoin evidence collecting?
Well, seeing evidence collecting relating to cryptocurrencies, broadly speaking.
Yeah, I mean, I have a darknet case.
Okay.
Yeah.
Are you at?
I mean, Bitcoin is, out of the 2,000 coins that exist, Bitcoin is the one that is tracked on the blockchain.
Mm-hmm.
So in terms of evidence collection at the government's disposal, there are several types of software that the government can use in collecting evidence from the blockchain. One such software is called Chainalysis, and that allows the government to track transactions on the blockchain by grouping them. This is proprietary software. The government has a contract with Chainalysis, which allows them to use the software. But as a defense attorney, if you say, give me the technology, because I want to check to see how you utilize the software, they will give it to you, because that would violate their contract. And so in that particular situation, they had to back that part of their investigation out, which of course doesn't do me any good, because it's sort of like unringing the bell. You already know what the answer is. But what they can do is they can manually check on the blockchain to see the transaction. Does that answer your question in terms of evidence gathering?
Yeah, I think so.
I think one of the ways we were talking about it, Nina, was yes, there are darknet cases and the like, but in the typical kind of fraud corruption case, has anyone seen the transfer of Bitcoin like in our hypothetical yet?
Right, but this doesn't matter. I mean, it's the same tracing, it's the same evidence collection. You still have to trace the transactions. And like I said, when you're dealing with a coin like Bitcoin, which is not like every other coin, because not every coin tracks to a blockchain like Bitcoin does, you can trace it.
Okay, well, we want to move down now to the whistleblowing element of our hypo. We know that it came to the World Bank's attention by way of whistleblowers. Given the panel we have, it would be interesting, I think, to look at how whistleblowing is dealt with on each side of the Atlantic. Steffi, do you want to start us off in terms of the US and what you've seen there?
Sure. So the main distinction that we've noted is the ability in the U.S. actually to get a cut of the potential award in particular situations, right? So the False Claims Act is the biggest one, which isn't implicated in our hypothetical, but if you are a whistleblower in the context of a fraud in connection with a government contract, a false statement with a government contract, you can share. I think the range is between 15 and 35%. But for purposes of our hypo, maybe the SEC, which is, and the CFTC have the same rules, about 10 to 30% of any award over $1 million, the whistleblower has the potential of getting a share of that, and that share is determined by the agency itself. You would have to report it directly to those agencies first, as what I believe, except Bill or someone can correct me if I'm wrong. And so that part we were talking about as a panel would be problematic in other jurisdictions, but in the U.S. It's kind of with the longstanding existence of the whistleblower share in the False Claims Act. I don't think that juries look at that with suspect, or maybe they would.
Right. No, that's right. And I think whistleblowers, beyond sort of the bounty aspect of it, there's sort of two different elements to it in the way the law is developed in the U.S. That on the one hand, you protect whistleblowers up front when they are first reporting evidence of a crime or misconduct. And there are lots of rules now in the U.S. that prevent retaliation, certainly by public companies, but even by private companies against retaliating against whistleblowers or even identifying them. But the flip side of that is that in the U.S., if a whistleblower actually has their own like eyewitness testimony rather than just like finding some evidence of a crime like an investigator, and they're going to go to trial, the witness has to actually appear, and so the whistleblowing does not extend to the trial. So if you're going to actually bring a case against a person or a company based on evidence from a whistleblower, once you're at trial, there's a constitutional right for the person to be able to confront their witness against them, including the whistleblower. So there's always that tension that at the beginning you protect the whistleblower, but at the end you have to protect the rights of the defendant over the whistleblower, and the whistleblower is out. And of course, that is currently an issue in the United States relating to the impeachment inquiry of President Trump, where there's two whistleblowers, and they're being protected, but Trump's people are trying to say, well, I have a right to know who's accusing me of something. And so that's one of the things that's sort of developing and may end up in front of the Supreme Court.
And Muireann here, in the UK at least, and I think Europe more generally, the idea of incentivizing an individual is just frowned upon almost. Can you tell us a bit more?
Not sure about Europe. I think there are moves in parts of Europe at the moment to try and see whether the American model works there. But in the UK, whistleblowers are almost treated, albeit they now have protection in terms of non-retaliation and non-disclosure, but they're almost treated as a species of informant. So you have someone who provides information in its broadest sense about wrongdoing. That could be an informant, it could be a police informant. And we've always had a very clear neither confirm nor deny policy in relation to informants in the criminal process, and that is right and proper, and that should remain. We have no bounty provisions here at the moment. We have, and Lisa touched on this yesterday, the UK system has always rather frowned, or rather thought it wasn't quite the right thing to have flippers, people who've come across and revealed wrongdoing and then given evidence. Our experience, although this may be more anecdotal than real, I suspect, is, and the expectation is, well, juries don't really like that sort of thing. Actually, I'm not sure about that. I think it depends on the nature of the evidence. I don't think they like it when there's no other evidence, because there's nothing to gauge it by. But actually, in fraud cases, you're always going to have, aren't you, or corruption cases, a body of documentary evidence. That's going to be your principal evidence. And if you've then got your flipper, I use the word rather flippantly, but you know what I mean. If you've got your the person who has done something wrong, admits it and comes forward, if you can treat that as the icing on the cake, and speaking as someone who's prosecuted a number of these big cases, well, that's how you should treat it. And if you can introduce it to a jury as, okay, well, we've got all of this information, and that's great, and that's, you know, that you've got it all there, but actually, just a bit extra. We've got a voice from the inside as well, and that I think can be terribly compelling. Hasn't been used very much, and there is a difficulty in the UK compared to what you have in the US. Our sentences here for fraud and corruption are so much lighter, so much smaller than the sentences that you have in the US. I'm not sure like Canada. I think
It's like UK.
you're like us, and therefore, whereas there is a huge incentive on someone to cooperate, plead guilty, not contest the proceedings because it might make the difference between, for example, 30 years and 4 years. In the UK, it might make the difference between 7 years and 5 years. It's not much of an incentive.
I mean, how would we change that, or how would you introduce the use of flippers more readily in that case? Because I think that's one of the issues that Lisa looked at yesterday, the idea of, you know, bringing over some of the tools from the US and her experience there, and maybe, you know, using them here to better the system.
I'm not going to answer that. I'm going to say watch this space, because I think you may find some significant developments in one or two cases in the next couple of years.
I'll leave it at that then.
It's interesting. The U.S. is, I mean, all of these have been very effective law enforcement tools. You know, having cooperating witnesses, flippers, and having these deals that you can cut. But there's also, and the sentences that the U.S. has are extraordinarily high. There's now something of a movement, I think, against that in the U.S. In the sense that there's a feeling that the U.S. Penal system is gone too far. So I think that there are people now who are trying to bring it back a little bit toward a little bit more of a happy medium. But one of the, I think your point on flippers is very important, because and I've tried some cases with some folks in here where, you know, sometimes the only thing you have as a defense lawyer when they've got the evidence against you and there's a flipper is you attack the flipper. You say this person has every incentive in the world to lie, he's got a deal or she's got a deal. But you know what? It almost never works. You know, and if that's all you got to persuade the jury, goes to your point. They get it. They understand that they have an incentive, but it's all disclosed to them. The person, you know, takes the stance that, yep, I've got a deal, but I'm still telling the truth. And, you know, it almost does, and there almost never works to just, that's not a way to win a trial in the U.S. is to attack the credibility of the flipper. You need to do it, but it's not going to win the case for you. And in most cases, you're going to have to do something else.
We've got, can I just say this?
Of course, yeah.
We've got very little tradition here of using those sort of witnesses in fraud cases, as far as I'm aware. We've got a longer tradition in using them in serious, normal criminal cases, particularly drugs cases, not so much murders, but drugs, serious corruption in terms of police corruption, things like that, where that's happened. And unfortunately, that's been one of the problems, because it's been some of those police corruption cases back in the 90s, which went badly wrong because of the treatment of the so-called supergrasses, as they're called here, and how they were treated and how material in relation to them was disclosed, that SOCPA, our act then came in, which, you know, can be a bit of a constraint, but I suspect it'll be handled better now.
That's a good, I mean, that's an interesting point. I mean, the nature of the offence, I mean, does it matter in the US what the offence is, or is it simply that's just how it will,
You can use a flipper in any type of case.
I think it's
I'd like
kind of
to
the
call it
MO,
this.
right?
Yeah,
Like you
exactly.
you go up the chain. I mean, there still are tricks of the trade, right? You would never have the big fish cooperate against the small fish, and you don't have that person sentenced before they testify, because then the actual quantifiable benefit that they received gets highlighted by a skilled defense counsel. But But at the same time, I think it's been not only long in use, but at the same time, it would be rare, Bill, you could comment too, where you're only relying on the cooperator's testimony. You will have corroborating evidence, or you will have wired them up so they're describing what it is you're actually hearing.
Right.
It would be rare to put them on the stand with just no corroborating evidence, because juries would look at it with suspicion.
Just be interested in your views. To what extent do you think such different whistleblowers have actually been motivated by that financial motivation, or do you think they come forward anyway?
I think whistleblowers are very motivated by the financial. I mean, there's a whole industry in the United States, the False Claims Act, that's built on lawyers, plaintiffs' lawyers, and whistleblowers making huge amounts of money on those cases. And then the SEC program has, I think, been an enormous success for the SEC, certainly in terms of the amount of money that's been turned
I'll make
out.
a distinction there, because I think there are different types of whistleblowers.
Mhm.
The true whistleblower, perhaps the prototypical whistleblower, is the corporate employee who comes across some sort of fraudulent conduct without real culpability on their end in the organization, reports it up the chain of command, which is routinely ignored, and then through their contacts goes to a whistleblower attorney, files a False Claims Act case, an SEC whistleblower complaint, and could obtain a bounty. In that case, the whistleblower really, unlike the flipper, has no real culpability. And generally speaking, in my experience, and having represented whistleblowers, a lot of times it is not the financial motivation that strikes that type of whistleblower, but it is the being ignored within the company, and the desire to change some sort of company practice that motivates them to go outside the company and reach out to law. On the other hand, you have the kind of gray area, where you have some of the whistleblowers, usually at a lower level employees. Take the usual case of the pharmaceutical sales representative who is marketing off label and paying kickbacks to doctors as part of the company's methodology or MO of how they do things. They, of course, have some culpability, but they are not usually prosecuted because they're boots on the ground, and the government uses those individuals to go up the chain of command. But a lot of times you'll find that those individuals file, False Claims Act lawsuits also, but they have some sort of culpability because they used the practice, they knew what was happening while they were being directed to do so by their bosses. They still have some liability. So I think there's a distinction, particularly in the U.S. scenario, between the prototypical whistleblower and the whistleblower who perhaps has some culpability but can use that for financial gain by filing a False Claims Act lawsuit, and the usual flipper or cooperating individual, say in the U.S.
And I think the motivation for the criminal turned prosecution witness is a reduction in sentence. And of course, we don't have the same incentive here or in Canada, what you're saying, Peter, as you guys have in the US. Hence, less use of it here.
Right, I agree with Bill. I mean, one of the unfortunate things about the False Claims Act now is that because of this, plaintiff's bar, basically, that oftentimes a person in a company, rather than using the compliance program and going to the compliance people to report a wrongdoing, if it's a person like Nick was referring to, they just go to the lawyer and they make a keep hand report. So that the company never even has the opportunity to exercise their compliance program. And that's really unfortunate.
And the SEC program actually specifically says, the SEC specifically blocks companies from requiring their employees to go through the compliance department before they go to the SEC. So the SEC actually has a policy that says, we want you to come to us first, and by the way, you'll get paid money. So I agree with you that, and obviously there are distinctions between cooperating witnesses, whistleblowers, and whistleblowers who have liability. For example, whistleblowers who have liability, very hard to get a bounty under the SEC rules. The False Claims Act is different, but when it comes to just basic human nature, there's a reason why the SEC is willing to pay out money. There's a reason why the False Claims Act has got so much support in Congress and both Republicans and Democrats, because people know that its financial incentives drive a lot of decision making and make people do things that others wouldn't do.
There's no question about that, and the whole structure of it incentivizes people to come forward because of the bounty.
Exactly.
On the back end.
Yeah.
I think there is this kind of other area of motivation for certain types of people who really seek to change things.
Yeah.
And those are the best whistleblowers for the government.
Exactly.
They don't care too much about the money.
Right.
They'll get it whenever they get it, but their real motivation is a little bit different scenario.
Yeah.
A little harder to attack their credibility.
One at the back, yes.
I actually work for law and
Mm-hmm.
and from my experience, there is a monetary incentive between 15 and 30%, depending on whether or not the government work the whistleblower attorney did. On average, I would say 17% would be recovery. And so although there is an incentive, I think it's also important to note that there are also very tight restrictions if you're a relator. If you're a defendant attorney, there's no disclosure bar, there's a company abroad, there's increased source protection, and a lot of these cases when they're brought, they're usually sometimes, well, I would say they're frequently lost on positive emotions or failure to plead and things like that. So it's a very big risk for the law firm that is running it actually to bring it on a continuous basis. So you have to do a very thorough upfront assessment to make sure that you, as a law firm, you're going to get a return on your investment. So yes, there is that incentive, and it's a very effective tool in the civil war, but there are also statutory and state law restrictions on being a whistleblower, and those are pretty high. The law was revamped in the 1990s, but there still are a lot of requirements. It's important to note that as well. It's not just let's go to the government and hey, there's been fraud in this company. The government may intervene, they usually have 60 days to do that, or they may not. They may say, no, we're not intervening, we don't have enough evidence, and then the lawyers can proceed in the United States or SEC on their own. That is an important consideration. Not just the recovery $30 million. Yeah, but you may have invested 5 years before in order to do that.
Okay, thanks for that. Bill, do you think with the latest whistleblowing issues in the US in terms of the White House and the political ramifications of that will change anything in this space?
It's a great question. I think it could. I mean, I think that there's a very the impeachment process is really a political process. It's not really a legal process as such. But I think that there is going to be a significant battle on the question of whether or not the identities of the whistleblowers must be revealed as part of the impeachment vote in the House of Representatives, and certainly at the trial of the Senate, if there's a trial, if he's impeached, which I think he probably will be. And so I think the question then will be, what is there's the thing called the Confrontation Clause, for those who are not American lawyers, in the Constitution, which says you have a right to confront your witnesses, which I mentioned before. And so there will be a significant question about whether or not the president has a right in an impeachment process. But again, that's sort of a political question. I think it could. I think that attitudes towards whistleblowers might change somewhat depending, well, I think it's unclear which way. And I think a lot of it's going to depend on which side of the political fence you're on. So, but I think it's certainly highlighting whistleblowers in a way. I hear people talking about it in ways that I've never heard people, like, normal people, non-lawyers, talking about it in ways they never really thought about it before, saying, maybe these people really should be protected. Or others are saying, well, how can the president defend himself if he doesn't know who's saying these things about him? So I think it could definitely have an impact.
Always dangerous to let politics get in the way of principle. I always think.
That's true. It's true. And this is entirely a political process, both sides. So
That's very true. I want to move on now to deferred prosecution agreements. Speaking of, interference, or I suppose crossover between the legal world and politics, can you maybe start us off in terms of the US use of DPAs, just either Stephanie or Bill, just to give us some background? I mean, they've become very in vogue, I suppose, over the past couple of years on this side of the Atlantic, and it's something that we adopted from the US, but in very different form, as we've taken them to be very different form. So if you could just give us some background as to what they look like over there.
Oh, who can start?
Okay, well, so that people know what a deferred prosecution agreement is, it's an agreement between the government and the company or individual. It's usually companies with DPAs, that the company will not be prosecuted for the offenses that it admits to in a statement of facts for a certain period of time, so long as the company pays a fine, pays a penalty, does not commit any further offenses, and this is actually administered by a judge or overseen by a judge for the period. Usually it's about 3 years. So the difference between a DPA and a guilty plea is that a guilty plea is exactly the same for a company, except that you're actually admitting you're convicted of a crime. So the company's convicted of a crime. So there's been a lot of debate, I think, recently in the United States about how different the two things really are in effect, because it used to be the case 20 years ago that a conviction, a guilty plea by a company, was viewed as being totally destructive of the company. The Arthur Anderson case is the classic one that led to really more DPAs for companies, because there was a view that companies can't survive a conviction, a criminal conviction. But DOJ started testing that with some banks, BNP Paribas, some other banks that were actually forced to take guilty pleas, Oxif, a big hedge fund, and convictions, and they survived. And so there's a question now about whether or not there's really much of a difference between a DPA and a conviction, because the critical thing for companies is that they have to admit to exactly the same facts. So there's a DPA. The difference between a DPA, you have a written statement of facts that says, I did these things as a company. I take responsibility for these things. A indictment or an information that would lead to a criminal conviction, exactly the same thing. And the consequence for the companies with third parties, like third-party lawsuits, debarments from the World Bank, is the same, because they've said, I did these things. So the difference is really the technical question of whether or not you have agreements with banks, you have lines of credit that say if you were convicted of a crime, your line of credit is canceled. So those are important issues, but there's a lot of debate now about how different the two really are in effect. And DOJ is moving toward more guilty pleas for companies because they think it's better, it's more fair in a sense, because people don't get DPAs, but companies do, and there isn't that much of a difference in the impact. So at least there's a debate on that. I think still every company would rather have a DPA than a criminal conviction, but there's still there's a bit of an erosion of the DPA.
I wonder how it's going to play out, though, right? Because one of the issues with the difference that we can talk about with the DPAs is that the DPA and its terms are largely controlled by DOJ, right? So the court okays the DPA, but it can't really dig into the terms of the DPA or require things like the monitor's report to be disclosed. There's every single time a district court tries to take some control, it gets slapped down. It's happened in the DC Circuit and the Second Circuit. And I'm wondering out loud, Bill, what you think about whether or not there could arguably be for an innovative company trying to figure out if they would rather have the court control their process than just DOJ's unilateral discretion.
Yeah, no, it's a very good point, and I think there are companies that are thinking about that now, because DOJ can be extremely difficult to deal with, and so the idea of having a judge, especially if you know the district that you're going to be in, because it's usually a U.S. Attorney's office that will work usually with a fraud section of DOJ for FCPA cases, and then for other cases it could just be the U.S. Attorney's office. So if you know the district, you can kind of figure out sort of who the judges might be. Some districts are bigger, and you might want to actually roll the dice and get a judge you think is actually somewhat reasonable, because then the DOJ is working on the backdrop of having to deal with this judge rather than just with you. And DOJ can basically force you to do almost anything. But if there's a judge, you might be able to say, look, at the end of the day, I'd rather take a guilty plea because as a company, because I know this judge is going to actually enforce certain things and is going to look fairly at my 3 years of probation. As a company, you might get something akin to probation. So there are reasons to do it. I still think vast majority of companies would rather have the DPA, but it is a question. And also, again, the financial penalties are basically exactly the same. You've seen companies pay billions of dollars for a DPA, right? And you've seen them pay billions of dollars for a guilty plea. So it's not really a difference in terms of the financial risks.
Just so we cover off all angles first, we do have DPAs and there are judges in the UK, and basically the judges oversee, the process, and they effectively ensure that it is done properly. Muireann, do you want to tell us a bit more about how they were introduced here and what the key issues are at the moment?
So DPAs are still relatively new in the UK. We had the first DPA, which you were involved in, Muireann, in 2014. Since then, I think there have been
4.
Has there been 4 or 5?
There's 5 in total now, yeah.
Okay, so 5 in all, which isn't very many. France started DPAs 2 years ago. They've already had 6, I think, possibly 7. There seems to have been a greater momentum there. One of the problems that we've got is, as if you're prosecuting these cases, DPAs can only attach to companies. They cannot attach to individuals in the UK. And prosecuting companies is really tough. Yeah, much easier to prosecute individuals, but actually prosecuting companies, bearing in mind our principles of corporate liability, corporate criminal liability, it's really, really tough. If you've got a very small company, a one-man band, or a couple of directors and very little else, then it's very easy, because it's very easy to show that that person or those people are in reality the company. Go after a bank, almost impossible, in my view, to be able to do it. And so there's very little incentive for a company, as opposed to the position in the US, to come forward in order to gain a DPA, because there's almost no prospect that they could be prosecuted. So what are they coming forward to do? Just say, okay, well, we've got this wrongdoing, and here we are, we're going to pay you lots of money. Well, it's not a very attractive prospect, because unless you're averting something else, but you're not really averting something else. It's still a process in very much, I think, in its infancy here. A reason to do it in the UK, particularly if you're involved in European procurement, so corruption and the like, is the European Union does have quite strict debarment rules which attach to conviction rather than DPAs. So a deferred prosecution agreement would not normally count as a conviction, so you could still continue to bid in relation to contracts. The other thing that's slightly different with the UK is at the stage of agreeing the DPA, a judge, and usually quite a senior judge, has to endorse that the DPA is in the interests of justice. And that can be interesting, that issue itself can be interesting. So 2 of the DPAs that we've had in this country have been against Tesco, which is our largest retailer. And, why would the largest retailer be subject worthy of a DPA if they've done something terribly wrong? Well, the judge looked at that, a very senior judge, and was happy with that. The other one that always comes to mind in this context is Rolls-Royce. Now, Rolls-Royce is an international institution, but it represents, in many ways, if you think of what is the best of Britain, it may be you'd think of Rolls-Royce as your exemplar. And Rolls-Royce went to extraordinary lengths to commit to a DPA, including the waiver of privilege across almost every element of privilege. Mind you, they had to do that because the levels of corruption that were being admitted to were also pretty unparalleled, both in the UK and internationally, including in the US. But even with all of that, the judge, I think after some hesitation, took the view, yes, it was in the interests of justice. So it's still a work in progress. We'll see how it goes.
So there really is a crossover depending on the circumstances and with the political and the legal. Peter, do you want to tell us what's happening in Canada at the moment on that front?
Sure. I mean, we're very new to the DPA game, but boy, did we ever, start off with a bang. Our system is just to start off with, our system is very similar to the UK system, but it's a fascinating insight into DPAs for all of us, I think, coming out of Canada because of a scandal that will likely, I think if the polls are to be believed, will have a bigger impact on the federal election, which is happening next week, than any other thing that's happened over the last 4 years for this current government. And it also gives us an insight into DPAs because about a year or so ago, I don't think 100 people in Canada would have known what a DPA was. And now half the country is an armchair critic, on DPAs. So for those of you who don't know what happened, I'll just quickly run through the facts. There's a very large company called SNC-Lavalin. Many of you probably have heard of it. It's a Canadian-based and actually British-based now engineering giant. And they've been getting into a lot of trouble over the last few years in terms of bribery and corruption. And one of those cases involved Gaddafi in Libya and charges of bribery and corruption. And that case was making its way through the legal system in Canada. SNC-Lavalin took the lead in lobbying for a DPA in Canada. There were other companies and other groups involved, but they were the big leaders. And successfully, I don't want to put it all on them, but there was a successful movement to have a DPA brought into Canada. And just last year it passed sort of as part of an omnibus bill, floated under the radar. No one really noticed it. And then SNC went and asked for a DPA from the prosecutors, and to its shock, the prosecutor said no. So then the lobbyists got, brought out of, storage and put on Parliament Hill, and they pushed the Prime Minister and other members of government to pressure the Attorney General to tell the Director of Public Prosecutions in Canada to do a DPA. And just as an aside, we have our Attorney General and Minister of Justice is a cabinet minister, wears the same hat. And she said no to the Prime Minister repeatedly, and was shuffled out of justice into veteran affairs, which in probably all our countries is a demotion. And it was viewed as a demotion there. The media found out about this and broke the story, and then this whole thing blew up and everyone suddenly understood what a DPA was, or quickly tried to figure out what it was, and became an armchair critic. Our justice minister, who is extremely popular because she was actually the first Indigenous or highest Indigenous person ever to have a post of that nature, resigned. Another minister followed suit. The chief of staff of the Prime Minister resigned. And the Prime Minister lost 5 points in the polls. What's interesting, though, I think for us, is out of that came a few lessons, I think, in terms of DPAs. One of them was the reaction of the public, because it's such a bit of a niche type of issue, and you don't really get large-scale reaction. In Quebec, which is the French part of our country, or predominantly French part of our country, which is where SNC-Lavalin is based predominantly and stood to lose thousands of jobs, or so it was viewed. But people thought it was a good thing. They thought, well, you know what? Why should this company be punished as opposed to the culprits at the top, which is, as many of us know, is often the reasoning for a DPA. The rest of the country thought, well, here is another example of corporate welfare. People just going soft on white-collar crime. And there was this division in the country which even now continues, where the Prime Minister just last week in a leaders debate was saying, I'm going to stand for jobs. And then everybody, the others are going, well, you're not standing for principles and the protection of the judiciary and judicial integrity and prosecutorial independence. It raises actually the issue of prosecutorial independence. I'm not familiar with the DPA case where in the UK or the US where politicians have actually, rolled up their sleeves and gotten involved to that level. And that may happen one day. I mean, what if somebody wants to go out and flout jobs and push something of that nature? So it has been a rare insight into what's going on. And I'm not sure there's going to be a DPA coming soon because it's just so toxic in Canada. Nobody wants to even touch one because it's just blown up in such a manner.
In Canada and in the UK, what is your ability as a defense lawyer to buy your way out through use of civil law? In the US, you can, particularly where there are parallel criminal and civil investigations, you can, at times, you have a well-heeled company offer to pay a huge amount of money in return for a civil settlement with no admission of liability, perhaps under the False Claims Act, and then quite any ancillary civil suits from there without a criminal DPA resolution.
Do you want me to go first? I mean, look, the biggest issue for Canadians is debarment as opposed to civil lawsuits. That seems to be the predominant concern for companies there. The debarment regime is very tough in Canada. So a distinction to the US, it's a much more rigid process. So often the focus shifts towards getting rid of the criminal process, getting some kind of, the theory being, because we haven't actually been having it, we haven't had one, but the theory being get rid of the criminal process, get a DPA, do not get a conviction, and then you can stave off potentially taking a major hit in your business from a debarment. And even if you're a company that has, let's say, hypothetically speaking, 20% of your business comes from public procurement, and we talk about cross-debarment, it's not just, it's never just one country, it's, your international organizations. How many companies can survive a sudden 25% loss of business? I mean, that, in S&C-Lavalin's case, I think it was, the majority of their business came from international contracts. So you look at, knocking all that out off the board. I mean, I don't know too many companies that can survive that hit.
As far as the UK is concerned, I'd like to say, and it may be a little idealistic, the prospects of trying to buy your way out should be zero. Whether there are competing civil interests is a matter which I think is entirely irrelevant to the SFO or the prosecution authorities in this country.
So a hand up here at the back. Was there anyone else who had a question? Maybe? Anyone else from the floor want to comment on this?
Just having experience in both the US, Canada, and England, it seems to be a little bit of intellectual inconsistency in terms of the outcome. Because in the Rolls Royce DPA, as I understand it, that was excellency, but there were no prosecution of the individuals underlying it. And so that creates a slight lacuna if you're accepting criminal wrongdoing of the company on behalf of people who work there, but then you make it possible. Does that create a perception that the company fought its way out and that there's not to be individuals prosecuted?
It's, yeah.
I'm just going to add on to the Tesco one. Conversely, there were prosecutions against individuals, not against the company. They were acquitted. As I understand it, in the published version of the published, the names of the individuals were named in that DPA, but then they were subsequently acquitted. And there's no procedure to rectify the published DPA, which is the oversight of those individuals that have been acquitted.
Yeah, I think my first comment is it's unfortunate. In fact, it's been difficult. I mean, the Rolls-Royce case, I think the reasons given by the director of the SFO was not that there was no evidence, sufficient evidence in that case, but there were other reasons why not to prosecute, whatever those reasons were. It gives an unfortunate impression, but there must have been reasons for it. Tesco and, in fact, Sarclad, which was the latest case where there have been prosecutions of individuals, resulted in acquittals of the individuals. Prosecuting individuals, as I say, is a lot easier than prosecuting companies, but there are no guarantees. As you well know, when I prosecuted you for the SFO, I singularly failed to convict your client in what I thought was an extremely strong case. So these things happen. But the timings of these is something that may be worthy of further debate, because whether you should go into that process first off against a company before going through the criminal process against the individuals may be a debate to be had.
Yeah.
Can I say Muireann was very kind in introducing me as the person who appeared in the first contested failure to prevent bribery case in this country. And I'm grateful for that. I ought to say, in the interests of complete and full disclosure, I lost that case as well.
Well, and on that note, I know that we have gone over time, so thank you for your patience. I'd like to thank our panelists for their insights, and thank you all for, again, attendance today.